We're going to start as a subcommittee. First and only bill up today, Senator Crawford, Senate Bill 337, whenever you're ready.
Thank you, Mr. Chair. I think it's interesting that I don't know that I ever come before the Judiciary Committee but twice this year. So thank you again for hearing my bill today. So Senate Bill 337 would allow victims who cannot utilize the Missouri Victims Automated Notification System, MOVANS, to receive electronic notification when an offender is scheduled for a parole hearing, transfer, or release. This certainly won't take any rights away from victims. It just gives another avenue for notification. And coincidentally, I don't have personal experience from this, but I do have a constituent that has a personal story that goes really well with this. So last fall, an offender was scheduled to be released from DOC, and my constituent, his mother had been murdered by this person, and he did not receive notification that this person was going through the parole process, and he was scheduled to be released. And so he actually found out through the community, and obviously he was very upset. While this won't fix his problem, I do think it gives us another tool that would be very helpful to get these notifications out. As you can imagine, most people don't live in the same place for 20, 30, whatever years, but just having another option to notify them, I think, is a good thing. And I'm happy to answer questions, but I do have somebody from DOC here that can probably answer questions as well.
All right, perfect. Any questions for Senator Crawford? Seeing none. Adam, I assume you're the witness from DOC.
Mr. Chair, members of the committee, we'd like to thank Senator Crawford for sponsoring this legislation. Just in brief, there's a small segment of a population that cannot get electronic notifications through the Missouri automated system. These are the cases where the court retains jurisdiction, such as like 120s and long-term drug treatment. The reason is because the system pulls from the offender database, and certain screens are not used when the court retains jurisdiction. Therefore, it doesn't automatically populate a notification. What this would allow us to do, we will still have to manage these cases manually outside the system, but what it would allow us to do is send the victims a email rather than a certified letter should they choose that option. And with that, I will take any questions.
Questions for Mr. Albeck? Seeing none, thank you for your testimony. We do now have a quorum. Brad, please call the roll.
Senators Luetkemeyer.
Here.
Shore.
Here.
Coleman.
Here.
May.
Here.
Roberts. Thompson Rehder. Trent.
Here.
Got a quorum.
We do have a quorum. I now make a motion that we go into executive session. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those opposed, no. The ayes have it. We are in executive session. Now make a motion that we bring before the committee Senate Bill 253. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary say no. The aye has it. Senate Bill 253 is before the committee. This is a bill that we actually heard a while back. This is a restitution bill currently under Missouri law. The only individuals who can seek restitution from the state are those who have been exonerated through DNA evidence. That's now mostly obsolete because all the DNA exonerations that are possible have already been conducted. What this would do is it would create a new avenue for individuals to seek restitution through the state for wrongful convictions, so long as their conviction was overturned on the basis of actual innocence, regardless of whether it was DNA exoneration or some other form of exoneration. We've kind of done a hodgepodge in a committee substitute where we rolled together the bill numbers for Senators Williams, Roberts, and Washington, and basically Senator Washington's bill, which ups the amount of restitution to, I believe, $179 a day. Currently, it's $100 a day, and it would, as I said before, broaden the scope of individuals who could seek restitution under the statute. So I'm going to make a motion to adopt the Senate committee substitute, but before I do, is there any discussion on the bill? Seeing none, I would now make a motion that we adopt the Senate committee substitute for Senate Bill 253.
Second.
Do I have a second? It's been moved and seconded. All those in favor signify by saying aye.
Aye.
I would also make a separate motion that we roll into the title of the Senate Committee substitute Senate Bills 253, 146, and 446. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye.
Aye. You
The ayes,
didn't vote.
the eye has it. You have adopted the Senate Committee substitute and rolled all three bill numbers together. I would now make a motion that we do pass Senate Committee substitute for Senate Bills 253, 146, and 446. Do I have a second? It's been moved and seconded. Any further discussion? Seeing none, Brett, please call the roll.
Senators Luetkemeyer,
Aye.
Schroer,
Aye.
Coleman, May, Roberts, Thompson Rehder, Trent. 5-0.
By your vote of 5-0, you have voted do pass Senate Committee substitute for Senate Bills 253, 146, and 446. Now make a motion to bring before the committee Senate Bill 128. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye.
Aye.
Those to the contrary say no. The ayes have it. Senate Bill 128 is before the committee. There is no committee substitute on this. This is Senator Thompson Rehder's bill that has to do with the enforcement of divorce orders. Basically says that if a party is refusing to comply with the previously entered order of the court, that the court has the ability to award attorney fees for the party who is seeking to enforce the divorce decree. Is there any discussion on this bill? Seeing none, I would now make a motion that we do pass Senate Bill 128. Do you have a second? It's been moved and seconded. Brad, please call the roll.
Senator Luetkemeyer,
Aye.
Schroer,
Aye.
Coleman, May, Roberts, Thompson Rehder, Trent. 4-1.
By your vote of 4-1, you have voted do pass Senate Bill 128. I now make a motion that we bring before the committee Senate Bill 129. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. To the contrary, say no. The ayes have it. The bill is before the committee. This is the shared parenting bill that creates a presumption, a rebuttable presumption in favor of shared parenting in family law disputes. It has to do with child custody. This was presented by Senator Brattin before we went on spring break. There is a Senate committee substitute that has been distributed that lowers the evidentiary standard for rebutting the presumption from clear and convincing evidence to preponderance of the evidence. I think Senator Brattin had indicated during his testimony that he was planning on making that change to make it more in line with the evidentiary standards we see elsewhere in the Family Law Code. Is there any discussion on this bill? Senator Coleman.
I'm going to vote yes to keep this going, but I have some concerns that we're not there yet on the bill, and I hope to see continued work from the sponsor.
Okay. I would echo that. So, is there any further discussion on the bill or the committee substitute? Seeing none, I now make a motion that we adopt the Senate committee substitute for Senate Bill 129. It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary say no. The ayes have it. You've adopted Senate committee substitute for Senate Bill 129. Is there any further discussion on the bill? Seeing none, I would now make a motion that we vote do pass Senate committee substitute for Senate Bill 129. Do I have a second? It's been moved and seconded. Brad, please call the roll.
Senators Luetkemeyer,
Aye.
Schroer, Coleman, May, Roberts, Thompson Rehder, Trent. 5-0.
By your vote of 5-0, you have voted do pass Senate Bill 129. I would now make a motion that we bring before the committee Senate Bill 367. It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. Senate Bill 367 is before the committee. This is the bill that I presented on before spring break. It has to do with the enforcement of non-solicitation agreements for former owners of businesses. It does not have any provisions in it relating to non-competes. There was no testimony in opposition to the bill. We had had some issues in the past where there had been some opposition to the legislation, but we worked through some changes this session to nullify those concerns. There is no Senate committee substitute for the bill. Is there any discussion on the bill? Seeing none, now make a motion that we do pass Senate Bill 367. It's been moved and seconded. Brad, please call the roll.
Senators Luetkemeyer,
Aye.
Schroer,
Aye.
Coleman, May, Roberts, Thompson Rehder, Trent. 5-1.
By your vote of 5-1, you'd have voted do pass Senate Bill 367. No further business coming before the committee for executive session. I now make a motion that we exit executive session. Do I have a second? It's been moved and seconded. All those in favor signify by saying aye. Aye. Those contrary, no. The ayes have it. We are out of executive session. We are back on Senator Crawford's bill. Any further witnesses in support of Senate Bill 337? Further witnesses in support? Seeing none. Any witnesses in opposition to Senate Bill 337? Seeing none. Senator Crawford, any concluding remarks?
It's a great bill. Just say yes. Thank you. Thank you for the opportunity.
It's a great bill. No further business coming before the committee. I now make a motion that we adjourn. Do you have a second? It's been moved and seconded. We are adjourned.